We've now got all our evidence in, we've made our closing arguments. The judge is going to listen to all of this, and sometimes judges ask questions in closing arguments, and sometimes judges even ask questions of the witnesses when they're testifying. At the end of it all, the judge is going to listen to the closing arguments, and then in some cases the judge will rule right from the bench. Sometimes they'll say, okay, here's what we're going to do. And in other cases the judges say, come back after lunch and I'll make my ruling. Or in other cases the judge say, I'm not ready to rule, I need some time to look over this evidence. I'll let you know, I'll try to rule by next Wednesday. And in other cases, I've had cases where I've got a case right now where I think we went to trial in, I think it's been 3 or 4 months and I still don't have a ruling from the judge. So sometimes they just either don't have time, or they don't have enough evidence, or they don't have time to review all of the evidence, whatever the problem is. But at the end of the day, you need a court ruling from a judge that says, here's what we're going to do. And the ruling is going to then be turned into a court order. And so it's going to be, here's the custody plan, and here's the spousal maintenance, and here's who's going to live in the house, and here's who's going to pay what bills, and here's how long the spousal maintenance or alimony is going to last, and here's where the kids are going to school, and here's who's approved babysitters. And I mean, there could be any number of things that is going to be ruled on by the judge that's going to now turn into a court order. And when the order is entered, then you obviously have to follow the court order. But in some jurisdictions, after the judge makes a ruling, sometimes the judges will call you in and do an oral ruling, and sometimes they'll do a written ruling. But usually in most places, and family law is usually kind of informal in this way, where you can say to the judge, well, Your Honor, I know that you said that he should pick the kids up at 5 o'clock from daycare, but what about on days when there's no daycare? Couldn't it be earlier than that? So the judges at the end of it, oftentimes they'll make a ruling, but then there's some tweaking that can usually go on, so you can kind of get, well, that doesn't look like it's going to work for our family, or where's the drop-off place going to be? The judge might say, the drop-off's going to be at McDonald's, and you don't like junk food, and you say, could we have the drop-off be at the schoolyard or something? So judges are, at some point, usually there's a little bit of a dialogue that happens about tweaking those rulings. But if you have a major issue with one of the judge's rulings, in most places you can ask for what's called reconsideration. And reconsideration is where you actually make usually a motion to the judge and say, you said he could have the kids until Monday morning, but I really wish you'd reconsider that because I'd really like to have them come back on Sunday night, and here's why. And that's where the judge is really going to read your brief and look at the evidence again. And to be perfectly honest, they don't usually reconsider, but sometimes they do. Sometimes they say, well, I hadn't thought about that. So, or, they might tweak things a little bit more. But so after the ruling is given and you've done all the tweaking with the judge in the courtroom, then there's usually a deadline or a time period within which you can ask for reconsideration of that ruling. So if you miss that deadline and then it becomes a court order, it's hard to get things changed after that. So now you're going to have a court order, which of course you have to read extremely carefully. You have to really know where the kids are, where the pickup is, where the drop-off is, what school are they going to go to. All those issues have to be carefully addressed in all of these orders, and they usually will be. So then a lot of people say, if they don't like the ruling, well, I'm going to appeal. I'm going to appeal this ruling. And guess what? Appeals are pretty much the only thing you can appeal is that when a judge applies the law improperly. It's almost impossible to appeal, I don't like this decision. I don't think my husband should be the primary parent or something. The appellate courts give great deference to trial judges because they're the ones who are there for a day or two or a week or however long your case goes, and they're not going to step in usually and change a ruling by a judge, and the judge didn't do that properly. Then you've got grounds for appeal on that issue. You can't say, they didn't apply the stock option formula properly and now I want a new parenting plan. So if you're unhappy with the decision and you want to talk to your lawyer about appealing, you need to just be aware that your lawyer's not going to be able to appeal a parenting plan just because it's not what you had in mind. We're not going to talk about appeals here because it's pretty rare that, to be perfectly honest, they're really expensive, and most people, by the time you've been through a family law trial, you are broke. And a lot of people just don't have the resources for an appeal at that point. But, which isn't to say you shouldn't do it, you should certainly talk to your lawyer about it, but the purpose of our discussions here isn't to talk about legal appellate stuff, it's just to let you know that it's difficult to appeal if you end up with a decision that you don't like. Which kind of takes us back to why it's so important to make sure that you're very well prepared for your trial, that you know exactly what evidence you want in, you know exactly what witnesses you want to have, exactly what you hope that they're going to say. You're completely prepared to have your ex cross-examined. You know how you're going to cross-examine his witnesses. You know how you're going to follow the rules of evidence. You've got a lawyer, or you are prepared to know how to make objections to the evidence to make sure that only reliable, authentic evidence that follows the court rules is before the judge for the judge to consider when she makes her ruling. So all of that stuff together brings you to the point where you're ready to go to trial, and at the end of the trial you're going to get a ruling that you're going to have to live with for a very long time. And it's going to come from somebody who doesn't know you, certainly doesn't know your family, doesn't know your ex, and has a very limited amount of time to make this decision because, as you know, the courts are all backlogged. So that's why most people say it's usually better if you can try to get your case settled even if it's in a mediation with a sort of a big fight between the two of you, because you guys are at the end of the day the ones who usually know your family the best. But if you have, you just can't agree on some stuff, and things that are common to get to trial is usually cases involving alimony or spousal maintenance or distribution of assets, or there's some stuff that sometimes people just can't decide on, and you end up in a trial for that reason. And you submit your information to a judge, and judges try their very best to be fair and to do as best job they can. But you need to think carefully before you go to trial, because it's extremely stressful and extremely expensive, and you just don't know how things are going to turn out.